Namaskar. Welcome to another session of administrative law. Here today we are going to discuss about judicial and other remedies. So whenever we are touching the law, or let it be administrative law or any law, some rights are related, and where there is some right, there is some remedy also, and that is embedded in the Latin maxim known as ubi jus ibi remedium. This is the Latin maxim ubi jus ibi remedium. It means where there is a right, there is a remedy. In another way, it means when a person's right is violated, the victim will have an equitable remedy under the law. That means if there is any infringement of right, there has to be some remedy. And for seeking that remedy, today we are going to learn administrative law in judicial and other remedies. Remedies can be of various types. Here we will learn about all the remedies available in the administrative law. So from this table we can make out the first category is constitutional remedies, second is statutory remedies, and third is civil laws. Constitutional remedies means some remedies already provided in the Constitution of India, like Article 32. It's a fundamental right also, and it's empowers Supreme Court for enforcement of the rights of the people. Then Article 226, it empowers the High Court similarly. Then one terminology is called SLP, special petition. It in Article 136, Constitution has given power to Supreme Court to permit any person on any subject from any court. If court permits, that permit is known as leave. Leave means permission. You need to seek leave from the court, and if court permits, anybody can go from any court, any quasi judicial, any administrative action to Supreme Court. It is known as paradise for the lawyers because there is no end of disputes here. So that is why it is known as paradise of lawyers. But for time being, for past few years, Supreme Court is strict and they don't want to give any SLP, and that is why 136 is standing. It is not revoked, but it seems to be inactive except in exceptional cases. Then one terminology is called exhaustion of remedies. So exhaustion of remedies means when there is some statute is giving some special remedies. For example, I will give like ESIC Act is a special statute and it gives remedy like ESIC code. So if there is remedy available in the ESI code, the aggrieved person need to visit first ESI court. He cannot go directly to High Court or Supreme Court. He has to go first to ESIC court. If he doesn't get remedy, then other places he can move. So he has to exhaust the available remedies provided by statute. That is known as exhausting of remedies. Then writs are there. 5 types of writs are there. We'll learn one by one. Then statutory remedies, as I told, ESIC Act provides some ESI code. Railway is having some tribunal. Land is having some tribunal. There is some central administrative tribunals. These are statutory remedies provided. So it may be from ordinary civil suit and it may go to appeal also. Then civil law. In civil law, 3 types of remedies are provided. One is injunction. Injunction means stay order. For example, if arbitrarily somebody is transferred from one place to another place and he thinks that some injustice has taken place, he can go to court of law and he can seek injunction. If court is satisfied, stay order will be issued. So this is the way how we are going to get injunction. Then declaration is it's not any separate type of right. It's only confirming the right. Yes, you are the legal on all of this. Yes, you are not legal of that. So only declaration of a particular right is comes under declaration. Then damages. Whenever we understand, whenever we learn law, there will be two terms, damage and damages. Damage means injury, damages means compensation. Damage is plural, damage is singular, damages is plural. So when damage is used, it's injury, your right is infringed, so that is damage. When the moment it makes plural, the terminology meaning differs. Here damages means compensation. Compensation may be in the liquidated form, in the unliquidated form, in exemplary it can be also be there. So these are the variety of remedies. One by one we'll understand here. When we study about Article 32 and 226, there are certain powers given to Supreme Court and there are certain powers given to High Court. So when we try to differentiate, the first differentiation is Article 32 comes under fundamental right. Article 32 itself is a fundamental right, whereas Article 226 is not fundamental right. It's a it's a constitutional right. Then Article 32 related to Supreme Court, Article 226 empowers High Court. Then under Article 32, Supreme Court can entertain only and only fundamental right cases. All injuries related to, all infringement of rights related to fundamental rights is entertained under Article 32 by Supreme Court. Whereas in High Court, under Article 226, High Court has power to entertain fundamental right as well as other remedies also, other cases also. So here the scope of Article 32 is narrower than the 226 of High Court. Another way, 226, Article 226 empowers, gives more power to High Court, more broader area to High Court than under Article 32 to Supreme Court, because Supreme Court is empowered under Article 32 only and only for the fundamental rights, whereas High Court is empowered for fundamental rights also and some other rights also. Then Supreme Court is having original jurisdiction in Article 32 and High Court is also having original jurisdiction under the section Article 226. So in this way, we can understand that High Court and Supreme Court both are having concurrent jurisdiction for fundamental rights. But as far as scope of powers is concerned, not height of the power, scope of area is concerned, High Court is having broader area than the Supreme Court as far as Article 32 and Article 226 is concerned. Then as we discussed, SLP, special leave petition, is taking special leave of the Supreme Court. It's a special power of the Supreme Court to be heard in appeal against any judgment passed by any court, any tribunal in India. So it is known as paradise of the lawyers. Then exhaustion of administrative remedies requires a person to first go to the agency which administers the statute. This process usually involves filing a petition, then going to a hearing, then finally using the agency for internal appeal process also. Then we come to the REIT. REIT is very important chapter as far as probation clearance exam is concerned. We should not have any confusion about the concept of REIT. So we must understand REIT from the basic point of view. So Writ is a special order of the court. Writ is a special order. There are so many orders of the court. Some orders of the court are known as writ. So a formal order in writing issued under seal in the name of a sovereign, government, court or other authority commanding an officer or other person to whom it is issued to do or refrain from doing the some act or specified therein is known as writ. So five types of writs are provided in the constitution. These all writs are entertained by the Supreme Court under Article 32 and High Court under Article 226. So first writ is habeas corpus. It's a Latin terminology, and habeas means have. Corpus means body, to have a body. So to release a person who has been detained unlawfully, whether in prison or in a private custody. If anybody is detained illegally, he can knock the door of High Court or Supreme Court under the writ of habeas corpus petition, and court will ask the authority to bring that person before the court. Court will listen, and if court is satisfied, court will release that person then and there. So this habeas corpus is very important writ in Constitution of India. It's very powerful. It's a liberty writ also. Then another writ is mandamus. Mandamus means we command to secure the performance of public duties by lower court, tribunal or public authority. When some duty is to be discharged by some public person, if that public officer is not discharging the duty, if he fails to discharge the duty, then the aggrieved person can go to the court filing the mandamus petition, and then court will hear and court will direct, look Mr. So and so, you are directed to do this thing, you are directed not to do this thing. For example, if some person goes to police station for filing an FIR, if police doesn't file FIR, it's a duty of the police to file FIR. That citizen is having right. Then that person can go to High Court or Supreme Court that please ask him to file FIR. And in that case, if court gives order, just follow this order. Then third is certiorari. Certiorari is to be certified. See what happens. Many times orders are passed by judicial or quasi-judicial or administrative bodies. The aggrieved person can go to the High Court or Supreme Court for requesting for issue of certiorari writ. If High Court or Supreme Court is satisfied, they can issue the order to quash that degree, to quash that order of the inferior court. Inferior court order can be quashed by High Court or Supreme Court under writ of certiorari. Then prohibition is there. When some litigation is going on, it is pending, it is in process. Some litigation is in process, and by the time the other party thinks that this court doesn't have jurisdiction, or it is just infringing the jurisdiction, or it is infringing the legality, he can go to High Court or Supreme Court, and court can ask that inferior court to stop proceeding henceforth. Last one is quo warranto, and the meaning is what is your authority. This is what happens when two government officials are posted at the same place. For example, one SSO Kumar, he is branch manager of some ABCD branch, and at that same time some SSO Nair, he comes that yes, I am going to take charge of this branch office. So there is dispute. No, I am branch manager. He says no, I am branch manager. So the aggrieved person can go to the court. Court will ask that person, the person who is holding the charge, That court will ask the person, please show your authority. Under what authority you are holding that post? If you succeed in proving the authority, well and good. If you don't prove, then you are out from the post. So this is the very effective remedy available in the constitution. So as far as habeas corpus is there, question arises who can apply. There is something called locus standi. We'll study in the next lesson. So locus standi means who can go to the court, who can tell something the court, and who can be heard from the court. So that is called locus standi. So as far as habeas corpus writ is concerned, locus standi is little bit relaxed. In another cases, the person whose right has been infringed, he will be allowed to the court. He will be allowed to go to the court. But in habeas corpus cases, generally the person who is detained, he can file the petition. If he is not able to file the petition because of some restrictions, his close relatives, his friends can file the petition. But in no case, no stranger can file the petition of habeas corpus writ. Writ of mandamus, as we discussed, so it's a command of the court. Court directs the public authority to do something or not to do something. And for that, conditions are that duty should be the public duty, it should not be the private duty. Duty must be absolute. That means he is bound to do the duty. There has to be some specific demand and refusal. If you don't go to the authority and by sitting at the home itself you expect that authority will do something, that is imaginary thing. So first there has to be some authority, then there has to be the right. You visit the person and you ask for the right and he refuses that demand, and there is some subsisting duty upon him. So if all these four conditions are satisfied, then the writ of mandamus can be requested by the High Court or Supreme Court. Then quo warranto, show your authority. On what authority you are holding the public post, that you have to show. So here also some conditions are there. Quo warranto is issued only to public offices. It's not applicable to private offices. Offices must be substantive in nature, means permanent nature, not temporary nature. Must be in actual possession of the office. That person must be in actual possession of the office. Then held office in contrary to law. Out of these two persons, one person is holding a post in contrary to the law. So that comes into the picture. And subsequent disqualification. On trial, it reveals that he is not competent, he is not authorized to hold the post, then subsequently he is disqualified, then only writ of quo warranto is issued. Writ of prohibition is issued. Writ of prohibition is issued by Supreme Court or High Court on the lower court, and its prohibition is in the form of a stay order. This writ is issued when a lower court or a body tries to transgress the limits of powers vested in them. So it can be issued only by High Court and Supreme Court against the lower court. Grounds are like judicial error, lack of jurisdiction, improper authority, incompetent authority, unconstitutional jurisdiction, violation of principle of natural justice. These are the some of the reasons on the basis of which writ of certiorari can be sued. So these are the remedies available with us in the administrative law. In next chapter we'll learn about some other chapter, and till that please keep on revising. Only few days are left for the probation clearance exam. Key is please keep on revising. As I told earlier, administrative law is going to carry 50 marks. 50 marks is administrative law, 50 marks is principle of management. So please concentrate upon the studies and try to fetch as high marks as possible. Many persons are asking, sir, what is the passing marks? Sorry, please don't bother about the passing marks. You bother about the highest marks. You try to fetch maximum marks. You will get 90% marks. I am hopeful. So we'll meet in next class. Till that, namaskar.